This program is brought to you by the Georgia Neurosurgical Institute. For over 50 years, rendering neurosurgical care to patients of all social conditions, treating complicated problems involving the brain, spine, spinal cord, and peripheral nerves, endeavoring to encourage quality care, medical research, innovation, and education on a local, national, and international basis.
My name is Joe Sam Robinson. It's my pleasure to have with us tonight Dr. Buck Melton. Welcome, Buck. We have different conversations on different subjects, and tonight possibly we could chat a little bit about the untimely death of Justice Scalia on the Supreme Court and what that might mean, and what are your observations on that? I know you're a constitutional scholar and you follow the workings of the court quite closely. Any comments?
Well, I'm not what they would call a court watcher who plots every move the way a day trader tries to follow the market. But yes, it is something I've followed fairly closely for many years. And my first reaction when I heard this was I was stunned, because if anyone had thought that a justice would die suddenly or retire, I think all of the money would have been on Ruth Bader Ginsburg, who has been in poor health for several years. So I think it's safe to say that no one saw this coming. And because Scalia is who he is, and because we are where we are in the election cycle, this is guaranteed to throw the already tumultuous presidential election of 2016 into even greater tumult. This is a game changer.
Well, he was on the Supreme Court for almost 30 years, a very
Yes.
long-lived justice. And he was a real leader on the conservative wing of the Supreme Court, was he not? And maybe you could talk about where the ideological split occurs with the originalists, whatever term is fashionable these days, versus the living Constitution model.
Yes, that's very good. Originalism versus the living Constitution is as good as any. Yes, he would have been at 30 years this September, I believe. And he was, by most standards, the most consistently conservative in terms of voting, if liberal and conservative are good ways to describe that. And really, for almost all of those 30 years, and perhaps a bit longer, the court has been almost perfectly divided among the liberal and the conservative camp, with one or two swing votes in the middle, which makes things very exciting. I won't say all, but a great majority of the truly hot-button issues decided over these 30 years have been by 5-4 splits or 6-3 splits, which diminishes the reputation of the court as being above politics. When you can see justices who've been appointed by Democratic presidents trending left and justices appointed by conservative presidents or Republican presidents trending right, it makes the court appear very political, rather than adhering to the law.
Well, isn't that a point? I mean, it seems to be a very, I guess, an issue of enormous political importance right now. The country is balanced precariously between different ideologies, and those ideologies are growing more extreme. I think an observer would say that.
Yes.
And the court is the job of the Supreme Court, presumably, is to interpret the Constitution and to sort of solve some of these great tensions that exist in the country. But how well does it do that? And do you think, I mean, I'm just a spectator on this and a lay person in regards to the machinations of the justice system, but it does appear that what the public would like to have is they'd like to have 9 people on the Supreme Court that paid attention to the law, or to use the word judicious in their interpretations, and carefully from the very top tier of power, attempted to do the right thing for the country.
Yes.
And it just seems that's not so much the case.
Yes.
Another problem is, I think, the idea that the justices cannot be intellectually neutral. In other words, you just can't be a person that has a tremendous intellectual power and they can say what they think the right thing is. Rather, they seem to be representing different ideological constituencies.
Yes.
And one of which is substantially not present on the Supreme Court. I've said this before. There are no Protestants up there, nor would you say there's anyone that's from sort of the middle of traditional America. There's no one that seems to be there, nor is there likely to be one. Apparently, any comments?
Probably not. Well, yeah, that's you've mentioned a lot of big things. Well, I'll take the most recent first, the lack of Protestantism. Yes, the court, I believe, is all Catholic and Jewish at this point, but how closely do these various justices subscribe to the religious beliefs or the religious communities that they set forward? For instance, you often hear that Scalia, who is a devout Catholic, really brought a lot of that to the bench. But in terms of capital punishment, he obviously did not, because the Catholic Church, it does not completely denounce capital punishment, but it does have a very strong bias against it. But Justice Scalia clearly had no problem at all with capital punishment, because based on his originalist viewpoint, capital punishment was clearly contemplated by the founding generation. So you could go through this with each of the justices and get different results. As to doing what is right, I think that most justices probably are trying to do what they think is right. The problem is they have radically different notions of what right is. And further, I think some of them would say it's not our job to do what is right by the country, it is our job to follow the law, which may or may not be morally right. So, yeah, there's a lot of disagreement on the court, and there has been, and there's probably going to be.
Well, let's beat around the bush a little, shall we?
Yes.
Going back to the idea of originalists, it would appear to me that to be able to, you mentioned capital punishment, and you mentioned Judge Scalia's idea that when there was an issue that appeared, one had to sort of get into the political and historical circumstances of the framers of the particular amendment.
Yes.
So doesn't that require a substantial amount of historical knowledge and judgment? And it's even mocked, I think, by calling it law office history. In other
Yes.
words, historians would say, well, if you're really trying to get a real grip on the story and capital punishment, well, it's pretty complicated, and maybe there were some limitations. But any comments about that? I mean, it's a very slippery slope, isn't it?
Yes.
If you're going to look at different eras and then try and transmit the language of the constitutional amendment, or actually something in the primordial Constitution, into the circumstances of the time. Isn't that tricky, a difficult
Yes.
exercise?
It is, and as a matter of fact, I some years ago wrote a rather lengthy article on how to do history if you're a lawyer, since my research had indicated that most lawyers really are highly deficient in terms of historical method. With Scalia's approach, it's a little bit easier, because he was two things. First of all, he was an originalist, by which I mean, and he meant, how would the authors of this document have understood it? But he's also a textualist, which meant that his main evidence for knowing what they meant was the text itself, as opposed to, for instance, statements that a drafter may have made out of doors at the time that he was drafting the Constitution. Scalia would have set no stock by that. So with him, it's the text, and therefore it's a little bit easier to run down.
Is it? I mean, in other words, if you were looking at the meaning of words and you looked at Samuel Johnson's dictionary,
Yes.
to me, if you were really, in a really arch academic way, if you were
Yes.
going to pursue the actual meaning of words, they've changed a lot.
Yes.
And the use of phrases have changed,
Yes.
and words by themselves are quite imprecise to start with.
Yes.
I mean, would an originalist actually get Samuel Johnson's, would his dictionary, Samuel Johnson's dictionary, be in his sort of law library to look up words as they?
With Scalia, I wouldn't put it past him, and you do raise a very valid point, and Max Radin once wrote a very diverting work on this called The Meaning of Meaning, which, as you can
Yes,
imagine, what this article is about. But I think what Scalia would mean by this is to take a word that had a long history, that had been carefully explored by the common law courts over a long period of time. For instance, corruption of blood or attainder of treason. that these are shorthand words that have concentrated a great deal of historical meaning in them, such that when they were used by a framer, you could have, without a great deal of difficulty, a reasonably accurate sense of what was meant. Now, of course, there's a lot of criticism of that. A lot of people claim that it can't be done, which is why not everyone on the Supreme Court is an originalist.
Well, now, just to go into this debate a little bit, the originalists, I mean, I can see the merit in their position, but just for the purpose of discussion, taking the contrary viewpoint, we've chatted before about how difficult it is to revise the Constitution.
Yes.
I mean, particularly in such a contentious time we have. The last constitutional amendment, I mean, when was that? I mean, it's been a while, hasn't it?
Well, if you don't count the 27th Amendment, which was this very weird amendment that was actually proposed as part of the Bill of Rights in 1789, but was not ratified until the mid-1990s, then you have to go back to, I believe, 1972 with the 26th Amendment, which was the 18-year-old voting amendment.
Which you could say, well, that's somewhat non-controversial, but
Yes.
the extraordinary, I guess, speed of which change is taking place in the country, and how the country is changing in different places. So it doesn't seem to be changing uniformly everywhere. And there's the idea that diversity is the summa bonum of our national, I guess, journey, causes all kinds of constituencies out there and more controversy. And one of the things apparently is out there, and reforming or changing the Constitution is it's hard to do it. And the framers gave a great deal of attention to protecting minority viewpoints and minority rights. Now, so if the country really needs to have change instituted, and the document just the difficulties of our culture and the constitutional framework make it impossible to put some slack in our societal tension. Mm-hmm. I mean, maybe it's the function of the court to
Yes.
do those changes. Thoughts?
Well, I think an originalist would say that you've probably stood the idea on its head and could point out times in our history, even when we had an increasingly diverse society, when the amendment process was no problem at all. And probably the best example of that would have been the Progressive era, the first 20 or so years of the 1900s, when we amended the Constitution no less than 4 times within about 6 years. The 16th Amendment, the 17th Amendment, which allowed income tax and direct popular election of senators, the 18th Amendment, which enacted prohibition, which was seen as a very progressive idea, and the 19th Amendment, which allowed women to vote. And at least 2 of these were against interest, that the state legislatures concurred in the 17th Amendment, which took away their right to elect senators, and an exclusively male voting population concurred overwhelmingly in the 19th Amendment, which took away their monopoly on the vote. And according to this argument, the thing that weakened the amendment process was an activist court that started often by 5-4 votes, amending the Constitution on its own, rendering the need for a formal amendment process less essential. And so it is atrophied over time because the court has been doing something it shouldn't be.
Well, that's a rather good point. But do you think the activist court was present in the 1930s? Or, I mean, if I make a comment, I mean, the court only I take the point. There's some logic in your statement, but the activist court seemingly has only there have been several decades when that wasn't the case. And I don't know. I mean, if the court stopped doing anything and just left it up to to society as a whole, what would happen? I mean, presumably the states would do something individually. I mean, it seems possible the
Yes.
states might do something.
Yes,
but putting changing the Constitution does seem daunting.
Yes. Well, and leaving it to the states, you make it sound almost like as a fallback or perhaps undesirable. But based on the original Federalist system as designed, that was the idea, that the states were actually to have the lion's share of governmental authority under the Constitution.
Well, let's discuss that a little bit. Let's
yes.
discuss that a little bit, because we were making the comment of how does society handle change.
Yes.
And the point would be that the country is moving ahead at different speeds in different places, and maybe it diminishes tension if the states do sort of assert themselves on individual rights.
Yes.
Though there would always be people that would be offended. If you were in state X and you went to state Y, it would be an offensive thing for you, and there'd still be a substantial controversy. Your thoughts?
Yes, and as long as people are going to have different economic interests or different opinions, a certain amount of that is unavoidable. And even when I think America was a lot more homogenous. If you go back to the colonial era, the early national era, when I'd say most of America was Anglo-Saxon or Teutonic, and a large part of that which was not was simply disenfranchised.
Yes.
You still, in that relative lack of diversity, you still had economic diversity, if nothing else. You had the South, which was agricultural, the North, which was commercial. This was one of the reasons why you hear the phrase taxation without representation. The Grenville government during the Stamp Act said, all of you in the colonies are commoners. There is a House of Commons representing your interests, therefore, of course you have representation. But the colonists replied, the colonies are so widespread with so many different economic interests from Massachusetts to Georgia that virtual representation doesn't matter. A commoner is not a commoner is not a commoner. A Massachusetts resident has totally different economic interests than a South Carolina resident.
Not to overkill it, but
yes.
not to take the point of the British government at that time, but the whole deal on the way the House of Commons worked, they were all the rotten boroughs.
Yes.
So most of the people that lived in England or the Britain were in exactly the same situation as people in the colonies.
Yes.
There was no difference.
Yes.
So it would be most people had no access to the House of Commons. They didn't meet the property qualifications. They had, or they were disenfranchised because they were Catholic, as far as that goes.
So we were all in an equally bad situation.
Which is a point that I think is neglected. I mean, so if it does appear that the colonists were acted as sort of spoiled children, would be the way that the British would say that.
And not to chase the rabbit
not that
too far.
I want to disparage my ancestors, but okay.
But not to chase the rabbit too far, and the tax burden of people in England was so much greater than those of the colonists. So it really increases the spoiled children idea. But the point is that you saw diversity even that long ago with a population that was overwhelmingly Christian and overwhelmingly white, overwhelmingly English speaking, and yet you still had diverse interests. So
well, we could say that actually in the framers of the Constitution, the idea of party and the interests, I think, were mentioned substantially by Madison. He's talking in going through the Federalist Papers. There are a lot of ideas that you're always going to have different, diverse, I guess, viewpoints that are predicated on economic differences or whatever, sexual differences, sectional differences.
Yes, but I think that takes us down a dangerous road if you say that since we are so diverse now that we can never agree substantially on anything, then we will simply become anti-majoritarian and let one single individual on the Supreme Court decide for us. I'm not sure if that's much better than saying that we have to amend the Constitution.
Well, let's discuss this a little bit.
Yes.
It does seem, recollecting my time on Earth here and the different disputes that have occasionally intruded itself into my knowledge. The Supreme Court, we've had controversies before, but this seems to be a huge, big deal.
Yes.
And is it because of the aggregation of power that the courts have just inherited, or by necessity they possess this superior power, and are they the people that decide what happens? We have over 300 million people in the country. You have millions and millions of people. And we have all these branches of government, thousands of employees, and these disputes finally appear in front of the Supreme Court, and the Supreme Court is factionalized, it appears to me, and quite unrepresentative. Let me say that again, quite unrepresentative.
Yes.
And if within narrow limits, it's always been that way,
Correct.
has it not?
Correct.
It's always been unrepresentative, but do the members of the Supreme Court have more than a parochial interest?
Yes.
Which I think I want to emphasize that. It appears to me that what is going on is there's a very narrow kind of framework about what's right and wrong, particularly with an activist court.
Yes.
So that they want to make America a better and moral place, which means, in a way, violating opinions of many people that have opposite notions of fairness, if I could phrase it that way.
And so as the court gains more and more power and involves itself in more and more things, our government becomes more and more elitist because it restricts more and more the ability of the people to decide for themselves in the voting booth. And I think that's one complaint that originalists would have on this matter.
Well, you know, one of the we could discuss that a little bit. I mean, we have Mr. Trump has acquired great amount of support from many quarters. And one could imagine that a lot of the support is referable to the sense of just being disenfranchised and just under the thumb of political correctness. And so he's captured a lot of people that have that populist resentment. And on the other side, I think you could say Mr. Sanders, likewise, is on the left. People feel like, well, their interests are not being represented appropriately.
Correct.
And the Supreme Court, do we think, can broker all that and remove that tension? And
I doubt it. I think the best that can be hoped for is the continued stalemate. And Scalia's death has thrown that potential for a continued stalemate into doubt. And the problem is that you have, I think what anyone would say is the most left-wing president that we've ever had in American history. You've seen this pendulum over the last 30 years. You have Reagan as the most right-wing, and then within just barely a generation, we have Clinton and Obama, who are far to the left.
Right.
You've had the most right-wing justice die during the last year of the most left-wing president's presidency. If it had been Ruth Bader Ginsburg who had left the court by any means, then this would not have been well, crisis is too strong a word, but this would not have been as big an event because presumably President Obama would have nominated to replace her another left-winger. And then the equilibrium, such as it is, would be maintained had she or he been approved. But what you have now is a left-wing president who is almost certainly going to nominate a left-wing replacement for a right-wing justice, giving the left probably a 6-3 majority. Even best case from the Republicans' point of view, Obama would nominate a moderate, which would still be viewed by the Republicans as a loss. You'd be going from dedicated right-wing to moderate. So once again, probable 6-3. So this is why this has become such a huge issue, and you have a lot of very responsible people in Washington and elsewhere, frankly, uttering a lot of inanities about how it is completely wrong for a president in his final year to nominate a Supreme Court justice, there's nothing in the Constitution that says it's wrong. He's president, he gets to nominate a justice, and the Senate gets to decide whether or not to confirm.
Well, let's just, I mean, maybe we could, I'll throw this hypothetical out there. What would happen if in fact the Republicans solidified their control of the Senate? They added even people, more people, and then a pretty left-wing, well, I think we could say Bernie Sanders is probably the farthest person to the left. He became the president, and we had a very die-hard Republican Senate. What happens if they just refuse to basically put another person in there? What occurs under those circumstances, and do we have a constitutional crisis? Is there any requirement that the Senate actually accept the presidential appointment?
Yes. Well, by no means would it be a crisis. Once again, if you listen to the pundits, if you listen to the strong partisan politicians, they make it sound like a crisis. The fact is the judicial appointment process has been broken for at least 15 years at this point. That during the Bush years, the Harry Reid Senate was blocking judicial nominees left and right, and the Republican Congress, the Republican Senate is now started doing that. Reid, as a matter of fact, in 2013, during the closing months of the Democratic Senate, actually rewrote the filibuster rules in order to allow Obama to pack the courts, which I think it was absolutely horrible, especially since Reid, when he was minority leader, claimed that the filibuster must never be touched. I mean, it was blatantly hypocrisy there. What happens here? Let's say we get, let's say Obama nominates a left-winger and the Senate holds him up, and then we get Bernie Sanders. You get a permanent 8-member court or an indefinite. That's not a crisis. It's an inconvenience. Normally what would happen would be, let's say the Republicans have won a case in the D.C. Circuit Court of Appeals, and the Democrats appeal it to the Supreme Court, and the Supreme Court splits 4-4. All that means is that the decision below stands, which means the Republicans have won. Now, it's not going to become a national decision, perhaps. It's not going to be a national resolution, but the beat goes on. Whereas if the Democrats had won below and the Republicans appeal, and you get a 4-4 split, once again, the Democrats have won in the court below, and that decision stands.
Well, now
it's inconvenient.
Isn't the paradox here, though, that if the different courts of appeal, I guess, states, so they're divided into different, I guess, geographical areas.
Yes.
If California has one opinion and Georgia has another one,
yes,
then presumably you'd have two separate kind of legal systems.
Yes.
So if you were maybe one, California would allow whatever illegal immigrants, if you want to phrase it that way, and
yes,
Georgia would not, or they would allow this, or they would allow that.
Yes.
And the inevitable confusion and controversy would be not in the nation's interest.
It would not be in the nation's interest, but once again, I would not use the word crisis. So the fact is that there are a lot of areas of law where that is true today. As a matter of fact, one reason the court decides to hear the cases that it does is it picks and chooses as to which things really do need a major national resolution. But then you've also got, remember, 50 other legal systems in this country that often have gross disagreements with each other. Each state has got its own government, its own legal system, its own judicial system, and they often go
yes,
different ways as well. So once again, it's inconvenient, it's inefficient, but it's a fact of life.
Well, what about in Georgia? The citizens of the Empire State of the South have the privilege of voting for their judges.
Yes.
They vote, and the system seems to be okay. Would it be reasonable if in fact the Supreme Court has really become a kind of a power nidus for different viewpoints that is only indirectly connected with the Constitution? Only the slimmest of connections
yes,
exist, and there people are really quasi-politicians. Would it be fair to have them elected? I mean, do other countries elect Supreme Court? I don't know. Do they do that?
Yes. The reason why you have an elective judiciary is the reason you have an elective anything is to keep the public servants responsible. The reason why the federal court system has effectively life appointments or good behavior appointments is theoretically to elevate these justices above politics. So they won't have their constituent is the law. Their constituent is the legal process and means of legal thinking. But if the justices are going to make no pretense of doing that, then why not make them elective? I mean, I think that follows. That if you're going to have an activist judiciary who are going to make the Constitution the way they think it ought to be, well, an elected politician can do that just fine. So why not?
So in a way, there's sort of, I mean, it seems to me, rather than a direct election, we have this kind of faux electoral system for the judges where
yes,
they go through this meat grinder of public, I guess, purview. The idea is you're going to, I guess, select a person that has at least some kind of intellectual abilities. I
yes,
mean, that's the fairness. I mean, you have to say the Supreme Court pretty much there are smart people.
Well, theoretically,
I don't want to give them too much credit, but I'd say they're pretty smart guys there.
I would say that something that bothers me in that regard is after the nomination and rejection of Robert Bork, which would have been a game changer, at least in the abortion department, presidents started picking lower profile nominees who were not really the leaders of the profession, people who had not published as much, people who were not as well known in their views, in the hopes of slipping them in. So I'm not at all sure, had the Bork nomination never occurred, that the people who we have named to the court since then would have been the nominees.
Well, a final comment. Our time is about
yes,
out. Do you think right now there's secret negotiations going on in Georgetown and some late night over some liquor, shall we say, when a prospective appointee is asked, you're going to vote for this and this and this and this, right? If somebody, are they asking,
Yes.
are they getting the support for particular ideology?
Yes.
They're going to demand the person's, they're not going to be neutral about it.
Yes.
And the respective of a particular appointee is not, won't throw them out, won't get up and
Yes.
walk out. Any
Well,
comment?
short of conspiracy theory, my sources indicate that's actually not quite how it's done. That if you do a survey of people who have been interviewed, whether successfully or not, for high judicial office, they're usually not asked in so many words. Now, obviously, you know something based on their writings of how they're likely to go, but not always. Anthony Kennedy and David Souter, who Souter's now off the court, but perfect examples of people who didn't quite turn out the way they were supposed to. Kennedy, especially, who moved much more to the left. Sandra Day O'Connor moved somewhat more to the left. The idea, the usual movement is to the left. But the idea is, we're going to hold you to this, and if you don't vote this way, something horrible is going to happen to your wife and kids. I hope we're not there yet in American government.
On that note, Bucky, thank you. We had a really enervating
Nice.
conversation tonight, so
Thank you, sir.
We'll have to talk some more. Thank
Right.
you.
This program is brought to you by the Georgia Neurosurgical Institute. For over 50 years, rendering neurosurgical care to patients of all social conditions, treating complicated problems involving the brain, spine, spinal cord, and peripheral nerves, endeavoring to encourage quality care, medical research, innovation, and education on a local, national, and international basis.